Mr. Minister now.
Madam, I am extremely grateful to a very large number of honourable members who have spoken on this bill. And of course, Mr. Gowda opened the discussion and made some very valid points. But one point which has been made across by several members, Mr. Kalyan Banerjee made this point, Mr. Saugat Roy has again raised it, that the standing committee had said that we need a new bill. And therefore, the reason why the standing committee said that we need a new bill, that the original 1988 bill was a small bill with 9 sections. It provided for acquisition of a property. Now, when you acquire, you pay compensation. In any acquisition law, compensation is to be payable. There was no vesting of that property in the government. It was an acquisition in favor of the government. And then the entire procedure, the principles of compensation, the authorities for acquisition and implementing, all was absent in the bill. The Law Ministry took a view that the bill, if all this is to be done by the rules, it would be ultra-virus the basic principles, because this would be a case of excessive delegation. And therefore, rules can't be framed. And from 1988 till today, 2016, rules have not been framed. One of the honourable members wanted to know whether any properties have been actually acquired. The answer is no, because the machinery for enforcement itself was not created. Though there are 2 judgments of the Supreme Court which interpret this act in order to tell us as to what is Benami and what is not Benami. The 1988 Act also has a provision for prosecution. And the provision for prosecution, prohibition and acquisition remained in that Act. So the prosecution provision is, under section 3, subsection 3, whoever enters into any Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years or with fine or both. So whoever subsequent to 1988 entered into a transaction which was a Benami transaction, either of the 2 parties would be liable for prosecution. So if we had accepted the recommendations of the Standing Committee, repealed the 1988 Act and recreated a new law in 2016, that would have been granting immunity to all people who acquired properties Benami between 1988 and 2016. Obviously, the acquisition now can't take place, but the penal provisions of the 1988 Act also would have stood repealed. And when a new Act with a similar provision would have come, it could only apply for a penal provision to properties which are Benami entered into after 2016. Now, anybody would know that a law can be made retrospective. But under Article 20 of the Constitution of India, penal laws can't be made retrospective. And the simple answer to the question is, why did we not bring a new law? Because a new law would have meant giving immunity to everybody from the penal provisions during the period 1988 and 2016. And giving a 28-year immunity would not have been in larger public interest, particularly if large amounts of unaccounted and black money has been used to transact those transactions itself. That was the principal object. Therefore, prima facie, the argument looks attractive that there is a 9-section law, you are inserting 71 sections into it. So bring a new law, but a new law would have had consequences which would have been detrimental to public interest itself.
Because if you want to penalize those things, from 1988 to now, so many years, any cases are already...
That is precisely...
Without that, how can you are going to do?
No, that is precisely the argument. Because the machinery for enforcing that act from 1988 was never created. Today that machinery is being made operative under the present amendment. Now, one of the questions which Mr. Gowda raised was, what is the protection being granted to the whistleblowers under this act? I'll deal with each one of the substantial questions which honorable members have raised. Now, under this act, whistleblowers need not get any protection, because we have a specific law for whistleblowers which across laws applies to all whistleblowers irrespective of the whistleblowing that they do. So a whistleblower can give you information about violation of money laundering laws or of FEMA or of income tax or of Benami transaction. So that information which a whistleblower gives, he gets a protection under the Whistleblowers Act. So each of the legislations in relation to which he gives information need not be made specific as far as he is concerned. Mr. Gowda then raised a question that the offences under this act are punishable up to 7 years. So it's a serious offence. Why have you made it non-cognizable? Now, this is a violation of a tax law, and a violation of a tax law is punishable. It's made non-cognizable because we don't want multiple agencies to come and start harassing people. Immediately, police would also come in and start harassing people. So the object is not to harass them. The object is that there must be a prosecution if he has violated this particular law. Now, one of the questions which you raised was that the Standing Committee has made a very valid suggestion that the word should be that the property or the asset acquired should be out of known sources, as against the original phrase known sources of income. You are absolutely right. The Standing Committee suggested that the word should be known sources and not known sources of income, because if a person is accused of having acquired a Benami property, he can legitimately say that this is not my income. I have borrowed this money from a bank, I have taken this money from another family member, and if he is able to show that, that's a legitimate defense. So the sources would be known, though it would not be a sources of his income. It was a correct suggestion which has been made. And if you see the list of amendments which the government has circulated, amendment number 3, 4 and 5, I have proposed to the Honorable House that the phrase of income in all the 3 sections which it is mentioned, in accordance with the recommendation of the Standing Committee, should be deleted, and the word in the amended section would be known sources and not known sources of income. So that suggestion has already been incorporated in the amendments that I have suggested. You also raised a question, which is a valid question, that at the appellate stage, there is a provision with regard to the right of representation through an authorized representative. Now, there are serious consequences, and one of the serious consequences before the adjudicating authority is that a person is liable to lose his property. And since the consequences are severe, we have provided in the original act a provision for right of representation before the appellate authority, but the original bill did not provide for a right of representation before the adjudicating authority. And therefore, amendment number 9 that I have proposed, in accordance with the suggestion that you have said, is The Benamidar or any person who claims to be the owner of the property may appear either in person or take the assistance of an authorized representative. So exactly the suggestion which you have made is already there in the amendment that I have proposed. You then raise this whole issue of why do we have 4 stages, the initiating officer, the acting officer, the adjudicating officer. The entire object of this is that you must have this case of acquisition, of confiscation of his asset, the vesting in the government. Different people must apply themselves, it must go in stages, so that there is no misuse of power by any one individual. After all, when there are different authorities at different grades which go and apply their mind, then obviously the matter has been seriously gone into. It's a protection in favor of the citizen, that there is no unfair action, that an officer out of one person may be vindictive, one person there is a possibility of going wrong, and therefore if you do it in various stages, obviously the possibility of error gets significantly reduced. The honourable member from the AIADMK raised a question as to why is the High Court been given the power to decide and adjudicate upon issues on which the adjudicating authority or the first appellate authority may not have decided. I think giving the High Court the power is important, because if some issue is of significant importance and in the entire proceedings has been left out, then it is obvious that some higher authority, before a property is acquired because a valuable right is being lost, all issues are thrashed out, and therefore there is no possibility of any issue having been left unattended which would have otherwise been a defense which is available. And this is the same reason why the power to record evidence is additionally being given to the appellate authority. Because if before the adjudicating authority some evidence is left out, and before the appellate authority, which is headed by a judge, a person who is about to lose his property says, well, I have a defense to make, maybe this document was not considered, so I want to place this additional document which goes to my defense. In all fairness, it should be allowed to be considered. And this is in accordance with the general principles of hearing appeals. Even in the Code of Civil Procedure, Order 41, Rule 27 is very clear. At the appellate stage, the power to introduce a new evidence which has been ignored or left out by mistake before the original authority is always there, and that's a part of the justice process itself. One important question which has been raised by several members as to why should the property vest in the central government, why not in the state government? Now, under all acquisition laws, there are acquisition laws or vesting laws which are in the states also. The Benami Transaction Law, wherein a property is registered in the name of a person who has not made the payment for it, or the income tax law, these are central legislations. Just as you have the PMLA, it is a central legislation. You have the SAFEMA, it is a central legislation. You have the NDPS, which is a central legislation. Similarly, you have several state legislations where state governments are empowered. Now, under all central legislations, where vesting of property takes place, it vests in the central government. Under state legislations, when the vesting takes place in the state government, it vests in the state government. At least I am not aware of any law which is a central law under which vesting or acquisition takes place, but the property rights then go to some other authority. They vest in the central government itself. Mr. Kalyan Banerjee wanted to know, and that's a legitimate point that he raised, as to the appellate authority not having been given a specific power of staying the order. Because when an appeal is pending, obviously the proper vesting should not take place. Now, as he knows himself, being an eminent lawyer himself, when an appellate authority has a power to pass a final order, the authority to pass a lesser order is inherently in that appellate authority. So since you have a power to allow the appeal and release the property from acquisition, inherently an appellate authority, in several legislations where there is a power of appeal, there is always a power of interim suspension of the order which is inherent in that power of appeal. Irrespective of whether it is specifically mentioned or not, there are pronouncements of courts to this effect. Which is the power which appeal to be filed in how many days? I think the Act is very clear. There are two provisions in the Act, because you wanted to know the power to file an appeal and in how many days is not mentioned. If he looks at the legislation itself, clause 30 says, the central government by notification may establish an appellate authority to hear appeals against the order of the adjudicating authority. So obviously the appellate authority will hear appeals. The power to appeal lies to that authority. In how many days will an appeal have to be filed? I think section 46 is absolutely clear. Any person, including the initiating officer, aggrieved by an order of the adjudicating authority, may prefer an appeal in such form and with such fees as may be prescribed by to the appellate authority against the order passed by the adjudicating authority within a period of 45 days. So even the power of the duration itself, the limitation period is also mentioned in the Act itself. One of the members wanted to know whether this power under section 59 to issue directions by the central government, will it interfere in the adjudicating power? The answer is no. 59(3) says that there are certain kinds of directions for administrative functioning which can be issued, but 59(3) very clearly says that no order, instruction or direction under subsection 1 shall be issued which require the authority to decide a particular case in a particular manner. So the directions issued have to be in relation to administrative matters and not in relation to other matters. Is this law in conflict with the Income Tax Act in any way? The answer is no. The Income Tax Act deals with the various provisions of taxation, the power to levy, the procedures, etc. This particular law deals with any Benami property which is acquired by a person in somebody else's name to be vested in the central government. So the two acts are supplementary to each other as far as this act is concerned. A question has been raised with regard to the non-applicability of the Civil Procedure Code under section 11. But under section 19, a procedure which is similar to the, some of the powers are similar to the Civil Procedure Code have been vested. This is there in all adjudicating acts. Section 11 says that CPC, ipso facto, on the facts of it, the whole CPC is not applicable. But since you have to hear matters, record evidence, etc., there is a defined procedure which has been defined in section 19 of the Act itself. A question was raised, एक प्रश्न आपने पूछा कि कई ऐसी प्रॉपर्टीज हैं जो रिलीजियस डाइटीज के नाम या होली बुक के नाम पे हैं, अब उसका मालिक कौन होगा? वो तो कोई बेनामी नहीं मान ली जाएंगी। इसीलिए इसमें सेक्शन 58 है जिसमें स्पष्ट रूप से लिखा हुआ है कि जो चैरिटेबल और रिलीजियस ऑर्गेनाइजेशंस की प्रॉपर्टीज हैं उनको एग्जेम्प्ट करने का अधिकार सरकार को है। सेक्शन 53
Please. Please.
No, but then if you collusively have if there is a genuine money property which belongs to a church or a mosque or a gurdwara or a temple, 58 says the government has a power to exempt it. But if you make an illegal business out of it, as you are suggesting just now, that the property is your Benamidar and you create a fake religious sect and start keeping Benami properties, then the government won't exempt it. Please don't do that.
Yes.
But obviously, if somebody plays a fraud, the government has the power not to exempt such a property on which a fraud is played.
Yes, yes, Minister. Yes, Minister, you are not supposed to answer something like that. Yes. Please, Prem Chandranji, please sit down. Take your seat.
Mr. Prem Chandran, it's very clear that 53 is meant for bona fide religious properties, not when religious properties are only being used as a pretext for tax evasion. A question has been raised whether under section 53, who would be liable? The person who acquires the property or the person who sells the property? The language is very clear, whoever enters into a Benami transaction, and obviously both these people have entered into a Benami transaction itself. Two very important questions have been raised. One is with regard to, several members have raised it with regard to power of attorneys and so on, or agreements under which, because of some peculiar reasons, an arrangement has been entered into, consideration has been paid, properties transfer of possession has taken place, but finally the title deeds have not been registered. Now in the original bill, these were not covered. But the committee, which Mr. Moily fortunately is here with us, headed, had strongly recommended that in accordance with the provisions of section 53A of the Transfer of Property Act, all these properties which are covered under these arrangements should also be included in this. The government has accepted that and introduced an official amendment in accordance with the recommendations of the Standing Committee. The last question which was raised by the Honourable Member, Mr. Sangma from Meghalaya, as to what happens to properties in several scheduled areas which are covered by the 5th schedule itself. Now, this act does not exempt those properties, but that exemption would be available under Article 244 of the Constitution. Article 244 provides for a 5th schedule to the Constitution itself, and the 5th schedule, clause 5, clearly says that wherever those scheduled properties are, the governor of that state has the power to exempt the operation of any central legislation to those areas. So if any such contingency arises, then the governor of the state where that property is located under clause 5 of the 5th schedule, prepared under Article 244, has the power to exempt those properties itself, which Mr. Sangma had.
1 minute. It is 6 o'clock. If all of you agree, time is extended, time of the House up to this bill getting. Thank you.
Madam, these were the various objections, queries which were raised because it's a technical kind of a bill. I have attempted to answer some of them, and therefore I request the honourable members, most of the members having supported this bill, it's an important measure that I commend to this House this bill for its acceptance.
Thank you.